Matter's ready, Your Honor.
And do we have Russell Beam?
He filed a formal response to the petition, it looks like, on August 11th. Ran a copy of that by to us late last night. I reviewed that. Typically, he comes to most hearings, at least he has in the past, for child support in the initial divorce case. So I'm somewhat surprised he's not present.
All right, I hadn't seen his response before. Let me take a quick look. Still no Mr. Beam. All right, I will find adequate cause, Mr. Zandy. And any other issues to address today?
It was also on for what do we do with the visitations. I would just ask that you adopt my client's proposed parenting plan. Mr. Beam has a lot of work to do. It would certainly from what's happened over the course of the past 7 or 8 months. So we're just asking that the visits on a short-term basis be FaceTime or telephone contacts 1 time per week pending these evaluations. Do you want to enter a GAL order or see where we get with the evaluations first?
Yeah, I think there's a lot of groundwork that's going to have to be done before we get to the point of needing a GAL, although I do note that Mr. Beam says he's going deferred on the DUI, so hopefully a lot of that started.
Okay. Yeah, what are we doing for presentations in front of Your Honor? Are we setting that for a special day, or are we just going to put it on the regular docket in 2 weeks? And
well, yeah, since Mr. Beam still hasn't appeared on this one, I think you can just send it to court administration and I'll sign it when they know.
Okay.
Mr. Zandy, you still there?
Yes, Judge.
I just saw Mr. Beam just showed up.
Okay.
Mr. Beam,
and I see Ms. Francis is online as well. Ma'am, your case, that's this afternoon at 1 o'clock, not 9 o'clock, unless something's changed that I'm unaware of.
All right, Mr. Beam, are you there?
Yes, I'm here.
Okay, well, I called the case a little while ago when you weren't.
I was having troubles accessing the Zoom ID.
Right. Well, Mr. Zandy, anything you want to present?
No, Your Honor, I think the pleadings are pretty complete with what the concern is. There's been a handful of major issues since February that don't seem to be getting any better. Kids are significantly impacted by this as they've been present to not only domestic violence issues, but the obviously in the car while Mr. Beam was driving it over 2 times the legal limit. There's been various police interactions. The neighbors have been involved. Again, I think the pleadings largely speak for themselves. Communications with the kids, again, I would submit is dangerous to be making the communications that he's said to the kids. And I think adequate cause is certainly a given. There's been a change in circumstance over the past several months, at least. These kids are being impacted. And I think setting the plan in motion of FaceTime visits and phone visits 1 time per week until such time Mr. Beam matures and essentially figures things out, I think is appropriate for these kids who are, again, being very negatively impacted by this. So I'll stand by what's in the pleadings and the police report and the pictures of his current wife's eye from the DV assault back in February and essentially leave that to Your Honor to do what you think is just given the circumstances.
Mr. Beam, anything you wish to say?
Yes, Your Honor. So since this incident, I have not been allowed to see the children since this current one, and which is the longest it has been since they have all been alive. I have tried to pick them up on my days. I have tried communicating with Miss Maida over this, and she has threatened me with a protection order if I were to file anything against her. I have also started my DV treatment, and I am waiting till this afternoon for a court hearing for my DUI, which I'm going to go deferred on. So at that time, I will be attending alcohol treatment classes for a 2-year treatment program, and I'm wanting and willing to do so. I've also been attending AA meetings. The incident last that happened in July was an isolated incident over a period of 5 months, now going on 6 with 1 day of alcohol. I have also acquired a new job since that incident because my mental health was severely declining because I was working for the petitioner's father and I was being treated unfairly for years. I am now in a good place and I've been following all of my probational rules. Like I said, I've been attending AA meetings. See that, and how I feel about this is the punishment has always landed on me. There's been incidences that have happened in the home of Lindsay Maeda that have not been brought forth to a lawyer or to the courts. And I have not punished her or seeked punishment for this. Like I said, I have not seen these children in a month, and that's the longest I've gone without seeing them, even working out of state since the time each one of these kids were born. It's causing more harm. The children call, when I do get to speak to them, they express that they deeply miss every single one of us in my household, including my wife and my stepson, which my stepson shares the same age as my 9-year-old son, Bronson, and they are all very close. It's been very hard not to see them, and I know I have screwed up, and I'm taking accountability for what I did, and I am seeking help. As I said, I'm willing to do all my treatments that the criminal courts have required because it is necessary for the best interest of the children and myself. I miss my kids, Your Honor, and I'm trying to make every step forward that I possibly can at this moment. And I hope that we can, we can stick with the original parenting plan and I can get my time back so I can start to rebuild with my children and fix my mistakes. And if court willing, I'm willing to agree to supervise visits until I have more time in these treatments under my belts for about 2 months. My mother has will sign a form acknowledging her duty as the supervisor in her home on my days and my times. But I'm hoping that if with that proposition after that, we can go back to everything being normal. I also saw in the parenting plan that she was requesting that she was requesting that all major decisions were limited to her, when in the original parenting plan, they were all joint, including education, healthcare, and extracurricular activities. And I see that now she is asking for all of them to be her and her solely, which I disagree with, because as I stated before, there has been incidences that have happened in her home that I have not reported. And we have always done things jointly. I'm asking that you take everything I have said into consideration as you make your decision, Your Honor.
Mr. Tandy?
That's a lot, and I would start by noting it seems completely disingenuous and kind of akin of a person who is not taking accountability and responsibility if they're blaming my client's father, who's the paternal grandfather, for somehow beating up his wife on several occasions and driving 2 times the legal limit with his 3 children in the car. That's a major concern. Secondary to that, if we look at his request that his mother be responsible as a supervisor, again, if you look closely at the police reports, you'll see that everyone had this assumption that Mr. Beam had gone to his mother's home for some kind of sanctuary. Again, I don't know if she's enabling that type of behavior or providing some kind of a hangout for him while things cool down at home. But regardless, that doesn't seem appropriate given the circumstances of this case. As he gets drunk, he gets in a fight, and he leaves and goes to mom's house knowing the police are coming. To suggest this was an isolated incident in July, again, there were 2 incidents in July. There was an incident in February. There's been incidents throughout. There was apparently some kind of a choking incident. And the information that we have just since February alone is extremely concerning. So I hope he's serious. I don't think he understands the ramification and the effect of his actions on these kids. And that's the part that scares my client and certainly concerns me. because it all seems to be kind of an excuse. Well, it was an isolated incident. Well, I'm doing what I need to do in the criminal matter. Well, it was Miss Maida's father's fault, and now I'm in a better place. And again, that just doesn't hold any kind of water. Now, when you look at the grand scheme of this, and again, the impact on the kids. These kids are in counseling. Now, these kids are trying to deal with the transition in their lives, but subjecting these kids to the weekends at dad's house when there has been chaos and mayhem again seems highly inappropriate and does not accommodate their best interests. I'm sure he misses his children. I'm sure the children miss him as well. But again, this has to be a healthy environment, and he has just not provided that whatsoever since the first of the year.
Well, certainly we've got adequate cause here. The incidents described are serious, and it is something of a minor miracle that none of the kids were injured. In terms of the parenting plan, I'm going to adopt the proposed parenting plan from Mr. Zandy's office. We'll make it 2 times per week in paragraph 4. And I'm not going to put a specific limit on the time. If the kids are interested in talking to Mr. Beam for longer than that, they can. Mr. Beam, I am pleased to hear you started the DV treatment. It sounds like you're on your way to addressing the alcohol issue also. Those are good things. That's the very first step. When you've got some time in both those programs under your belt and can show that you are making headway, we certainly need to take a look at this again. As Mr. Zandy said, I'm sure you miss the kids. I'm sure the kids miss you. But my number one concern is their safety. And so that's where we are right now. Talk to Mr. Zandy about getting a guardian ad litem appointed. I want that to happen after you've got a little bit of treatment in both those programs under your belt. We can get that started and see how we get this back to a more normal relationship. And we'll set presentation in 2 weeks on the 5th at 9 o'clock.
What was that?
Thank you.
So you want to put it on this docket or on the commissioner presentation?
What time's that one?
Commissioner presentation at 1.
Okay, we'll set it on the 5th at 1 o'clock then for presentation.
Presentation of what?
The orders that reflect what I just ruled.
Okay.
And I see Ms. Fowler is on. Ms. Fowler, I don't see Ms. Cotto here. Did you resolve your discovery issues?
I did supply Ms. Cotto the discovery as ordered by the court. I haven't heard anything from Ms. Cotto. I would really like to resolve all these matters, as this has been going on for 5 years, and Mr. Reed hasn't seen our daughter in 5 years, and I haven't even been paid childcare or anything, and it's been court ordered for the last 5 years. I'm just
so the issue today was the discovery. Since Ms. Cotto is not here, I am going to assume that you've supplied the answers to her satisfaction. So we'll strike the matter.
So what does that mean, Your Honor, that the proceedings are done?
That the issues regarding providing discovery appear to be resolved.
Okay, so I will have no further court hearings?
I'm sure there will be further court hearings. The process is still ongoing.
Is this for child support? Because I'm extremely confused here.
Okay, the only issue that I'm dealing with, I haven't read your entire file. It's pretty big. The only issue I'm dealing with is the one that was put in front of me on the motion, and that regarded discovery. Based on Ms. Cotto not being here, I'm assuming the discovery is taken care of. If that's incorrect for some reason, she will note it back up. If there's anything you want to address, you can bring a motion as well.
I don't know if the prosecutor's here or not, because I do know they were seeking.
Not on this matter. As I said, the only thing going on today was the issue of discovery.
Okay, thank you, Your Honor.
All right. Rice and Rice.
Good morning, Your Honor. That matter's ready. Brandy Jeffers on behalf of James Rice.
Good morning, Your Honor. Casey Sanders on behalf of Sarah Williams, formerly known as Rice.
All right, counsel, go ahead.
Your Honor, husband in this case, or father, is requesting the court vacate the final restraining order dated March 31st, 2023 per Civil Rule 60 and award attorney fees. This motion is timely as the order was entered less than 5 months ago. Problem here is the restraining order was based on misrepresentation. And quite frankly, there was no motion to extend the restraining order that had been filed with the court. The only real issue before the arbitrator was child support. Father did agree that the issue could be heard and eventually agreed to the restraining order after reassurances that his gun rights would not be affected. Unfortunately, they were. Father was pro se at the time. There were 4 people present: father, the triple LT, the arbitrator, and mother's counsel. The arbitrator doesn't remember what was said. Both father and the triple LT do remember the misrepresentation. So father was really confused and upset when he received notice that the restraining order did forfeit his gun rights. Should be noted that the order must be vacated even if the misrepresentation was innocent. And quite frankly, it is highly likely here that there was confusion because there are restraining provisions that would not affect his gun rights. And he believed that that's what he was agreeing to, and Your Honor's aware of that. But that wasn't the order that was actually entered. Father relied on statements of the only parties, quite frankly, with a law degree, and it was to his detriment. He disagrees that the 2021 stipulation to arbitration applies. That ended with entry of final orders. And quite frankly, the subject matter of that arbitration is not the subject matter before the court. Father attempted to resolve this issue out of court several times with no success. Whether there was a basis to extend the restraining order or the existence of an unfiled contempt motion is not relevant to the issue before the court today. Father denies frivolous litigation. The only motions he's brought since final orders was to modify child support when the child turned 18 and started living with him, and the CR 60 motion, which he only brought when he received notification that he had lost his gun rights and was threatened potentially with arrest because he was not aware of it. He also requests attorney fees. We've tried to resolve this issue out of court with no success. Thank you, Your Honor.
Sanders?
So, Your Honor, we filed a counter motion asking for the court to either dismiss and send this matter to the arbitrator and award fees and CR 11 sanctions, or if the court does consider it today, dismiss the action, award fees and sanctions, and restrict further needless litigation. Your Honor, the sole basis for the CR 60 relief is the false statement that both myself and Judge Nichols represented to him that the restraining order would not have any effect on his gun rights. I'm just going to do something that I don't like doing, Your Honor, here, but parrot the information in my client's declaration here. In order for the court to grant this relief, it has to accept that the respondent was advised by Judge Nichols and myself that there would be no effect on his gun rights. It would have to, by extension, accept that Judge Nichols and I both made misrepresentations in violations of numerous ethical and professional rules. It would have to ignore the fact that all these statements are self-serving hearsay. It would have to ignore the fact that the discussions in arbitration are protected by the arbitration order. It would have to ignore the fact that he was not advised by his triple LT that this may have an effect on his gun rights. It would have to ignore the fact that at no point in the back and forth over these proposed orders was there any question or clarification or request for a change in language over potential gun rights, and ignore the fact that the order itself explicitly states that this may have an effect on your firearm rights. The truth of the matter here is that he agreed to this order, and now he wants to try and engage in useless, needless litigation to try and get out of the agreement he made. There is an established pattern of coercive control on Mr. Rice's part in needless litigation. He's been held in contempt twice. There is a long history outlined in the declaration of the abusive use of litigation in this case, and it doesn't address the factual statements that my client needs this restraining order regardless of the effect on his gun rights. The court needs to dismiss this and award fees and sanctions. We did everything we could. We sent a detailed letter with numerous exhibits outlining why this relief was inappropriate. It is not supported by the findings of the arbitrator. It is not supported by the statements of the arbitrator, myself, or my client, and it has no basis in fact or law.
Ms. Jeffers?
Well, Your Honor, I don't think you can bring a CR 60 motion back to the arbitrator. And quite frankly, as the court saw with wife's filings in this case, we did address this with the arbitrator, and the arbitrator just says that they have no memory. And so I think it is proper before the court. I mean, the reality is we wouldn't be here today if husband had any idea or father had any idea that this would affect his gun rights. And that was something that he was very concerned about. It was addressed in the arbitration. And unfortunately, the information that was given to him was not correct. Again, whether the arbitrator believed that we were talking about, in the box provisions as opposed to outside the box, I'm not sure. But the effect is still the same. We are asking that order be vacated today. Thank you, Your Honor.
Okay, so the preliminary issue is whether or not this is still subject to the original arbitration agreement. I read that agreement carefully. It's all encompassing as far as the litigation at that time was concerned. I don't see anything in it that I think extends the arbitration agreement beyond completion of that original arbitration. So I think I do have authority to address the issue today. The issue that's in front of me today is that the participants in the prior proceeding disagree on what was said. I find it difficult to assume that Judge Nichols or an attorney or an LLLT would make any representation that someone would not lose their gun rights if there was a protection order against them, but maybe it happened. That's a factual issue that I don't think is appropriate for me to decide in this setting, because we've got dueling affidavits. If Mr. Rice wants to pursue this, I think there's going to have to be a hearing, a live hearing in a courtroom, or the electronic equivalent of a courtroom. So the finder of fact has the opportunity to decide who they believe carries the day. So number one, the court has the authority to hear Mr. Rice's motion. Number two, if Mr. Rice wants to pursue it, he's going to have to set it for a hearing.
Your Honor, are you willing to set the hearing at that time, or do you want me to just, it's probably going to be a special set.
My understanding is now that these things have to get set on that trial readiness calendar. We can go ahead and put it on that calendar right now if you wish, though.
That would be wonderful, Your Honor, since we have all the parties here.
Well, we don't have all the parties here because Judge Nichols is a party,
Well,
or
he's
at least
certainly
a witness.
Yeah, he's certainly a witness.
Right, but we're setting a date to set the hearing date. We're not setting actual hearing.
When is that? Or else
We've got Wednesdays at 11:30, I think,
1 o'clock.
or 1 o'clock, I'm sorry.
A week from tomorrow
That will work.
be the 23rd at 1 o'clock. That work for you, Mr. Sanders?
It does. That's just to set the hearing, correct, Your Honor?
Correct. And Mr. Sanders will raise the other issue. I don't have an answer to it because it's just kind of coming up right now. You may well end up being a witness in this as well, so you'll have to figure out how you're going to handle that.
Understood, Your Honor.
All right. Thank you, counsel.
Thank you, Your Honor. Thank you, counsel.
Your Honor, Tiffany Jensen for respondent, Penny Hensley.
All right, counsel, go ahead.
Thank you, Your Honor. We're here today on a motion to enforce the judgment. We've submitted a proposed order that allows Mr. Hensley to recover his animal mounts that are in possession of Miss Ames, and we've asked that she be ordered to make accommodations for a third party to obtain those animal mounts, or to for writ of execution so the sheriff can obtain them. We're asking for $3,000 in attorney fees, and alternatively, the court could enter a money judgment for the value of the animal mounts. Respondent didn't file any response to our motion or file an objection to our proposed order, so I'm going to object in advance to the respondent submitting additional facts to the court. This is a property awarded to Mr. Hensley, and it appears that Miss Ames is asking that the court convert that property over to her. Miss Ames has not acted in good faith, but she's asked Mr. Hensley to come on her property after this May 31st to fix a fence and to look at a septic line, so she doesn't have a problem with him or having a third party come over to her house if it's going to benefit her. The other thing I'd like to point out is May 31st was not that long ago. I can understand Miss Ames's position if we were out over a year, but the details of obtaining the animal mounts were left up to third parties, which neither party can direct. They're not paid agents, so they were left up to the son-in-laws, and we've made arrangements, or he contacted them at least in writing just a few weeks after May 31st. I'd like to also point out that the same stalled the process of entering the orders until May 4th. We had a settlement on this issue on May 16th, and so that further delayed whether or not the orders were going to be entered. We're just asking that Mr. Hensley be able to obtain his property that's in wife's possession. Thank you, Your Honor.
Ms. Jensen?
Thank you, Your Honor. Just based on Mr. Hensley's pleadings alone, he's in violation of the order. The arbitration happened on March 16th, and shortly thereafter, Mr. Hensley was able to arrange to remove his guns and ammo by April 23rd. Any alleged delay in the signing of the divorce judgment had no bearing on his ability to coordinate his sons-in-laws to retrieve his guns and ammo, which he did without incident and without problem, nor should it have prohibited him from arranging with his sons-in-laws to remove the mounts by the date that was in the final order. He was well aware of it. It was May 31st. And by his own attorney's admission, his first attempt to coordinate with his sons-in-laws happened a couple weeks after that deadline. Furthermore, Your Honor, if you carefully read the divorce order, it says relating to the animal mount and the guns and ammo that Mr. Hensley will arrange to remove those property items from Ms. Hensley's home within 45 days of March 16th, 2023. That makes the deadline, Your Honor, not May 31st, but April 30th. So he blew past that deadline and he blew past the May 31st deadline because apparently agreements and deadlines don't mean anything to Mr. Hensley. And then he admits today that he didn't reach out to anybody until at least 2 weeks after the deadline that wasn't even the deadline. And now wants to have her pay for attorney's fees or things of that nature because of his failure to abide by the court order. We'd be asking this court to deny his motion and award us attorney's fees for having to respond when it was Mr. Hensley who is the one who has failed to comply with the court's order and the divorce judgment. Thank you, Your Honor.
Any reply?
The arrangements were supposed to be made with the son-in-laws contacting Miss Ames because there's a protection order in place. The parties don't have direct communication. So they were the ones that are supposed to make the arrangements. So Mr. Hensley did what he could. They said that they had some problems getting everybody available to go over there over a weekend to make it happen. And then when they finally made an availability, she said, no, you have to call the attorneys to have them figure it out.
I'm going to object to the hearsay. They could have filed declarations if that was accurate, Your Honor.
Noted, thank you.
And then the respondent didn't file any response to this case. So I don't think attorney fees are appropriate. And again, it appears that the respondent is reading the judgment saying that if he doesn't get his property by May 31st, then it's converted, and then these animal mounts are now the possession and they're belonging to Miss Ames. So she's asking the court to also modify the property award in that respect, and that's not appropriate. Thank you, Your Honor. All
right. Well, the decree is pretty clear. Mr. Hensley had a due date to get this done and he didn't do it. Pure and simple. So the question is, what do I do about that? I don't think that turns the property into Ms. Hensley's property, but the onus is on Mr. Hensley, not on her. So what I'm going to do is this. Mr. Hensley's got one and only one shot to pick up the animal mounts. That will happen on September 16th at 10 a.m. Ms. Hensley is awarded $750 in fees. If Mr. Hensley doesn't arrange to pick the animal mounts up by that date, he doesn't own them anymore. They're hers. Presentation. So September 5 at 1 o'clock.
That works, Your Honor.
That work? Mr. Ball?
Yes, sir.
That matters. Ready. Bear with us as we switch the camera
Thank you
over,
both.
Judge.
And we have Mr. Angelico here in the courtroom with his client. All right. So did the $350 get paid?
No, Judge, and the order is actually for $1,500. And today, it's pursuant to my email from my client last night, the $200 that Mr. Mortensen has historically paid has not been paid either. We were before Your Honor about a month ago, setting this matter in motion as to the potential for jail time. Judge Evans took some pretty special precautions and notified Mr. Mortensen that it was in fact on the table, appointed counsel for Mr. Mortensen, and to date, no payments have been made.
Mr. Angelico?
Thank you, Your Honor. Mr. Marr was appointed to this case, Your Honor, and unfortunately he is not able to appear today as he's on vacation this week. I'm here on behalf of Mr. Marr. Mr. Marr is requesting that the Office of Public Defense be allowed to withdraw in this particular case. There are several bases for that, Your Honor, in that we are primarily attorneys versed in criminal law, Your Honor, in the criminal rules. We have no attorneys that are versed in family law, civil rules, civil court rules, or civil cases necessary to give Mr. Mortensen effective assistance at counsel. Our office also would have to account for this case under the caseload standards, as we are short-staffed. Mr. Marr and any other attorney do not have the time required by this case to represent Mr. Mortensen. At one time, our prior director did have us contracted in civil case to do minor and adult guardianship cases. We were under contract. There was funding under that contract. a large majority of those cases were sent to private family law attorney to handle, various private family law attorneys, local area to handle. Unfortunately, under this case, we do not have funding necessary to contract this case out to a family law attorney. It may seem straightforward that it's a criminal contempt, whether he's jailable. However, I think this case is intertwined with a dissolution case. For example, Mr. Mortensen, I think, has filed a motion that has not been argued because of, I think, the notice requirements, which addresses in part his income, monthly living expenses, and also an argument concerning an offset of equity that was equity in the family home from the sale of the couple's residence that has not been accounted for. That I think Mr. Mortensen is in his motion is basically saying that he would be doing offset because she has taken this portion of the equity in the home. This is a temporary, under temporary orders, Your Honor. This is not a final dissolution. And we believe that Mr. Mortensen needs to be represented by somebody versed in family law, since it's kind of intertwined with the other issues. And I believe that certainly, I think his motion needs to be heard first if there's any question about offset of that equity. I would note that we have had contact with Mr. Mortensen. I did do a cursory look when Mr. Moore indicated that he would not be available, but it's interesting to note, I think on the original order that ordered the spousal support was a notation by Judge Evans, something to the effect of that it would be reviewed, or there would be a look when the final dissolution of assets occurred. So, at this point, Your Honor, we would argue that Mr. Mortensen needs to be appointed somebody versed in family law that would be able to compile all of the parts of this case necessary to defend him. And we're just not capable, Your Honor, I don't believe, to effectively represent him in this area.
Mr. Mortensen, do you have any objection to the motion of the Office of Public Defense to withdraw?
I do not.
All right, I will allow him to withdraw. Okay, here's where we're at. Mr. Mortensen, as I told you last time, jail is on the table. It appears since that time, you have chosen to just ignore that. So what I'm going to do is this. Have a seat in the back of the courtroom. I'm going to go figure out who we are going to appoint to represent you. We're putting this on for next week on this same docket. And I suggest you have a long conversation with whoever that attorney is. Because if I were deciding this today, you would be sitting in jail until you pony up, however long that takes. You understand the jeopardy you're in?
I understand.
All right, have a seat in the back. We'll come back to this one.
Here, Your Honor, representing Michael Miller. And I believe it's pronounced Amiskita.
Yeah, I'm here.
All right. So Ms. Holder, go ahead.
Your Honor, we're here to modify the parenting plan to include child support. Mr. Miller has had custody of their son since October of 2022 due to removing their son from Ms. Amiskita's home because he had gotten a restraining order against Ms. Amiskita's partner, Mike Chaddock. And Ms. Amiskita currently has supervised visitations, but she still lives with the father of the other two children, Mr. Chaddock, who again still has that DVP against him. On July 31st, Mr. Chaddock attempted to have the DVPO lifted in front of Commissioner Carney, but there was no chance of circumstance and there was no adequate cause to drop the DVPO. As a result, it is going to drop in December as an operation of law. And so that DVPO is still in place. And Ms. Amiskita also has a DVPO in place because of Mr. Chaddock's DVPO. Ms. Amiskita went and picked up her and Michael Miller's son at school immediately after he dropped him off. And there is concern that Ms. Amiskita would expose and take Buddy, Mr. Miller, and Ms. Amiskita's child in front of and to the home where Mr. Chaddock is. At that hearing on the 31st, where the DVPO was denied, or excuse me, dismissing it was denied. Commissioner Carney noted it appears Mr. Chaddock still doesn't know why a DVPO was originally granted. He isn't taking responsibilities for his actions. He doesn't even know what domestic violence is, and he needs 6 months of DV classes and to complete those. Ms. Amasquita still believes that she is not a victim of domestic violence, and so it is unlikely at this time that she is going to get 50-50 custody, which was what she had with Mr. Miller prior to October of 2022. She is getting her supervised visitations at this time, and as I understand from both Ms. Amasquita and from my client, she is following that. We do have a hearing in the next couple weeks in front of Judge Fassett to see if there is going to be any change in circumstance regarding that visitation. But as of right now, I do not see any reason that Mr. Miller should not be getting a child support from Ms. Amasquita, as he is has sole custody of their son, and he also has a 50-50 custody with the mother of another child. And so we would ask at this time that Ms. Amasquita be paying child support for Mr. Miller having custody of their son, and that we also would ask that child support be covered in back pay going back to October when he first got custody.
All right, Ms. Amasquita, is there anything you wish to tell me?
So I was trying to get my son and I was trying to see him, but I didn't know what I had to do because I didn't have an attorney. I couldn't afford an attorney. My protected order put on me was only because of the protected order put on Mike. And when I tried to fight it, they didn't care because of the order on Mike. And that was placed on me in January. And I haven't fought mine because there's no point, because they're just going to say, I have to have it on me. I tried fighting it with proof, but Commissioner Carney didn't take my proof into consideration and just said no and put it on me. Like, I tried fighting my protection order so I could see my son, but I couldn't. And the whole I've done everything I've been told to do for the court. I took my domestic violence assessment and that was fine. Mike took his. I still haven't seen the other party's assessment. There's just a lot in the case that's going on, and I submitted all my stuff for child support, like stating like I'm struggling financially and I'm having a hard time.
Let me ask you a couple of questions, ma'am. So do you have other children residing with you?
3, yes.
And are
I have
those
my
your children?
sister and my baby and my 4-year-old.
Okay, and are you receiving support for them?
Yes, I get state assistance for having my sister with me.
What about for your children?
My other children, their dad isn't working. He's been looking for a job, so I've been supporting them.
All right, and where are you employed?
Walmart.
And how many hours a week are you working?
Right now, they've cut hours. So right now, less than 30.
All right, you said you make $16.64 when you work days, $19.61 when you work nights. Is that accurate?
Yes.
All right. Ms. Holder, when I look at this with the other children in her home, I think any child support puts her below the self-support minimums, doesn't it?
I believe it does, Your Honor. I would like to note that she is choosing to work part-time. If Mr. Chaddock is still in the home and he has not found a job, then he would be able to stay home with the children, which doesn't, I'm not sure why Ms. Amasquita has not either been able to bump up to full-time or why she has not been able to find a second job. While I understand that there is a hardship and she is, at danger of putting her below the poverty line, Mr. Miller is also experiencing the same issue with his hours being cut, and he is also supporting and does not get child support from his other child. So I understand that the court is between a rock and a hard place here, and I do not think that the amount that the child worksheet has put on line 17 is a good indicator. I believe, quite frankly, that it's too high, and I do feel for Ms. Amasquita, but I do think it is appropriate considering she does have 2 people in the household who are able to work, whether they are working, part-time or unable to find a job. There are plenty of jobs that are hiring, and as to why Mr. Chaddock has not been able to find a job and Ms. Amosquita is working part-time supporting 3 children is beyond me. So I do not believe that the child worksheets are accurate and asking for, over $500 is the correct amount. I do think she should be paying some child support to Mr. Miller.
Okay, well, Mr. Chaddock may or may not have legitimate reasons for not bringing any money into the household, but he's obviously not a party to this proceeding. And it sounds like both Mr. Miller and Ms. Amosquita are having problems about getting full-time hours. I can't fault either one of them for that, I don't think. So right now, I'm just going to reserve the issue of child support because I think any award at this point would put her below the self-support guidelines. If counsel or anybody's financial situation changes, we can raise the issue again just by noting it on for hearing with whatever additional information rather than having me file a motion. But I won't order any support at this time.
Understood, Your Honor. Thank you.
Thank you. And I believe all that leaves is to address Mr. Mortenson's issue.
Your Honor, I failed to, is the court going to do a bench order that allows OPB to, Mr. Martin, OPB to be.
If you would fill that order out and just leave a blank for so-and-so appointed in your stead, and I'll go back and try and find out who we can appoint. Okay, so I have Mr. Morgan's office on the line. Please let Mr. Morgan know I'm appointing him to represent Stephen Scott Mortensen. The case is Mortensen and Mortensen. The matter is a criminal contempt. Did you get all that? Pardon? Okay. I'm also going to instruct Mr. Mortensen to call Mr. Morgan's office immediately. And the matter is on next Tuesday, the 22nd at 9 o'clock. So, Mr. Mortensen, you need to call Daniel Morgan's office. I'm not sure who the attorney is who will be representing you. You need to call him immediately, get in to see him immediately, because a week's not a whole lot of time given what's going on. You understand that?
Yes, sir. Mr. Mortensen, it's a 6-hour trip over here.
I'm sorry?
Mr. Mortensen lives at Idaho 100, so it's a 6-hour trip over here.
Well, he needs to talk to Mr. Morgan about that, and we'll see where we go. But right now, he's due here in person next week, unless a judge says otherwise.
We'll request that I'll come to Mr. Mortensen, and you can also go by Mr. Morgan's office before he leaves back.
I think that would be a real good idea.
Thank you, man. Thank you.
Thank you, Judge.
Yes. So, Ms. Bliss?
Yes, Judge.
I would suggest you give Mr. Morgan's office a call, let him know the lay of the land. And if it may very well be that a week is not realistic for them to take this on, and I don't want to drag Mr. Mortensen over here just for a continuance. So if you'll talk to Mr. Morgan's office about that as well, so we can sort it out realistically.
I can do that, Judge. Thank you.
All right, thank you.